Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a third-degree felony. Range of punishment is anywhere from 2 years to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
So I'm just trying to figure out what conditions of bond to set for you so that you'll be successful on bond. The motion to revoke, that's something that will be addressed at a different date. So we have previously, when you're on bond with this, for this case, there were issues of alcohol. So I'm just specifically talking about this case, not anything else. So we have alcohol issues. Do we have issues with marijuana? And by issues with marijuana, I mean you've used marijuana before. State, are you ready on this case?
Yes,
For our bond request? And counsel, I'm assuming you didn't file a motion, correct?
I did not, Your Honor. I'm gonna file my notice.
All right, court is calling 2021 CR 6023, State of Texas versus Israel Mankata. Could I have the parties announced for the record for the state?
Jason Garrett.
Defense?
George Schaefer for probation or defendant, Your Honor.
And are you Mr. Mankata?
Yes.
All right. We are here, your attorney is, because there's a warrant out for you, your attorney is asking the court to set a bond. And state you have no objection to the motion being oral?
No.
All right, defense?
Judge, to the extent that he's on a deferred adjudication, obviously a bond is allowed by the Code of Criminal
Yes.
Procedure. We would ask for a bond amount similar to what he had when he got this offense in the first place, which is $10,000. I want to note two things for the court. One, he has brought himself in and surrendered himself, which is a good thing for him to do. Secondly, the other nice thing for me is he has hired me to represent him on this matter, and I will do so vigorously. We would like to get him bonded out of jail so he can continue working and taking care of his 10-month-old baby.
Okay, all right. And so that the record can be clear, I'm aware of the defendant's previous criminal history because he is on deferred adjudication out of this court.
Right.
So I'm aware of some issues that he's had in the past as far as with alcohol. So are there any mental health issues that the court needs to be aware of?
No.
No, Your Honor, not that I'm aware of.
All right, can you raise your right hand for me, please?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
It's fine.
All right, you can lower your hand, state your name for the record.
No.
All right, so is there any mental health issues with you?
No.
All right, other than alcohol, which that's something that's related to the charge that he's on for out of this court.
Right.
Other than alcohol use, are there any other drug uses issues?
No, just the day of, I used the THC because I was going through depression because I haven't been able.
Oh, no, no, no. Here's the thing. I don't want to talk to you about
Okay.
the reason for the motion to revoke because,
Just the day of, I was around someone that was smoking.
all right, so let's not do around someone.
Okay.
So
Yes.
what, this is what I'm trying to figure out. One, I don't want to have you respond without conferring with your attorney to anything that has to do with the case, because I'm just here for your motion to revoke. You're on deferred adjudication, so you're legally, you must receive a bond because it's deferred adjudication. Technically, it's not a conviction. So I'm just trying to figure out what conditions of bond to set for you so that you'll be successful on bond. The motion to revoke, that's something that will be addressed at a different date. So we have previously, when you're on bond with this, for this case, there were issues of alcohol. So I'm just specifically talking about this case, not anything else. So we have alcohol issues. Do we have issues with marijuana? And by issues with marijuana, I mean you've used marijuana before.
Yeah.
Okay, so we have the marijuana issues. All right. And no mental health issues ever been diagnosed? All right. So, defense, what bond amount are you requesting?
Judge, I would request a bond similar to what he had originally. I think $10,000 will ensure his appearance at any court proceedings. I think this young man understands he was in a bad position, made a mistake, and is ready to accept the responsibility going forward.
Yes, sir.
All right. So I have reviewed the motion to revoke, so I can see if there is any allegations of you not reporting or any issues with that? All right. State, what are you asking for bond?
The state's not opposed to $10,000 bond, Your Honor. That was what was previously instead, at the beginning of his, abatement case.
All right, so I'm going to set bond at $10,000. What I'm going to require in probation, we're not addressing his motion to revoke, but is he able to receive alcohol treatment still with you all, even though he has a pending motion to revoke? All right. So then what's going to end up happening is you're going to have to do some sober meetings. And whatever depression you were going through at the time of the alleged new offense, are you seeing some therapist or somebody to address those issues or no?
No.
All right. Counsel, do you know of some place he can go, someone he can talk to? I know he can talk to people at the sobriety meetings and that's confidential, but do you think he needs something other than that?
No, Judge, I believe also the DWI is going to take care of the alcohol rehab and the classes that are attending to it.
Okay. Do you have insurance?
No, ma'am.
All right. I'm just going to tell him you need to go and see someone at the Center for Healthcare Services, just somebody to talk to. You may always say it's great to talk to somebody, and especially sometimes it's best when you can talk to a stranger and you can just let loose. All right. So I'm going to ask for a referral. Well, technically not a referral. I'm going to require you to go to Center for Healthcare Services. All right. Is there anything else that he needs? And I think the Center for Healthcare Services will probably help you with your probation.
First row.
All right. So
Start taking room.
it's an evading case, so it's not a violent case, so they may be able to do a walkthrough. I'm not sure. Deputy Laura, and then we need a setting for this motion to revoke.
Right.
What date are you looking at, counsel? And is it going to be contested, you think, or no?
No, Your Honor, it's not. I know that his DWI is set on the 17th of July, I believe.
All right, and I don't know if they've ordered it, but I'm gonna order no driving as a part of his.
Conditions.
Yes. All right. And so then you say it's set for July 17th?
Yes, Your Honor.
Do we need it on July 17th, or are you all allowed to do anything with DWIs as a part of this or no?
Well, I mean, it's a misdemeanor, Judge, so I mean, we could always do something on our case. And then they could, I mean, I don't know what, if you haven't worked the case out yet.
I haven't even seen discovery on it yet.
Yeah.
I
so
think
don't-
after they get discovery, and we could
Then
definitely,
we can talk.
we could definitely talk here and resolve this, and then they could go resolve it there also.
All right, so
After.
it's just that I don't,
Okay, pause right here. This is a subtle but important courtroom moment. The judge is actively trying to balance two things: keeping the process moving efficiently and not leaving the defendant in legal limbo. That line about not keeping him out in the wind, that's judicial shorthand for avoiding unnecessary delays that could impact someone's rights or compliance. But here's the question for you. Do you think speeding things up helps the defendant, or risks rushing the case before all evidence is reviewed?
want to keep him out in the wind for more than a month. And you're saying July 17th?
That's when the DWI is set, but if you want to set this sooner, fine by me.
Yeah.
You said it like in 30 days, Judge. I think we could possibly work something out here, and then I can tell the misdemeanors to follow that.
All right, so what I can do is I'll recall it for June 25th.
Yes, Your Honor.
And probation, he's going to be reset for June 25th, but you're going to need to report to probation. Is there any way to do that or no?
Once he gets out.
Yes, Judge.
All right, so you're going to be reset for this case for June 25th, but you need to make sure you report to probation. I'm going to give you the reset form. Once you sign it, Deputy Laura and Deputy Mejia will do what they do.
Thank you, Your Honor.
You're welcome. Let me give you the reset form.
Not for the next.
There you go.
Excuse me.
Sure. Counsel, do you want the letter back?
Yes, Judge, let me.
All right, if you can give him his letter back. All right, thank you.
They didn't get the copies. Judge.
Hmm.
They didn't get the copies.
Oh,
Sorry.
that's okay.
Thanks, Beard.
Yeah, there's a warrant.
Deputy Laura, can you move them down to the end? Richard, can you guys go down to the end so that the court reporter will be able to hear? All right, thank you. Court is calling, thanks.
That's all.
Court is calling 2024 CR 4998, State of Texas versus Jennifer Rose Pinelli Huerta. Could I have parties announced for the record for the state
Jason Garrett here, Your Honor.
defense?
James Stump, defense.
And are you Ms. Huerta?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. And probation, this is an application. Ms. Huerta, did you review the document entitled Application for Deferred Adjudication of Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do. Your Honor.
State, are you proceeding on the indictment as presented? Ms. Huerta, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up?
This is one of the most critical legal turning points in the entire hearing. The defendant is formally waiving constitutional rights to retrial, confrontation, silent seal, in exchange for a plea deal. That's not just paperwork, that's irreversible strategy. And notice how the judge keeps confirming understanding. That's to protect the record from appeal later. But let me ask you this, do defendants really understand the weight of these rights when they say yes in moments like this?
Those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, sir.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Huerta, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine that's unagreed to.
That is.
The state is recommending deferred adjudication. They're taking in consideration 2024 CR 5142, and there's $114 restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, sir.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
None, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, and no contact with Richard Earl Robbins and Dennis Lee Brooks. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence? All right, and state, before I excuse you to continue to confer, did you want to be heard on the $1,000 fine or no? All right, thank you. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client was a student previously. She'd like to go back to school and get her life back on track. She's wanting to work towards that and her children.
All right, so who is Richard Robbins
An ex-boyfriend.
and who is David Brooks?
A friend that I had met one night through mutual friends. I don't even communicate with them. I don't even know them.
Do you have children?
I have one. I have a daughter.
And what's her age?
She's 11 months.
And who is she staying with?
With her grandmother. I'm actually on a CPS case at the moment.
And when were you placed on the CPS case?
The day she was born.
All right.
So,
And when was she born?
July 18th.
So why are you with these people when you have a CPS case?
Now this is where the tone shifts and you can feel it. The judge is no longer just processing paperwork. They're evaluating judgment and credibility. Bringing up CPS Child Protective Service raises the stakes dramatically. This isn't just about a criminal charge anymore. It's about parenting, responsibility, and decision-making under scrutiny. And the judge is clearly skeptical. Be honest, if you were in that position, how would you explain being in that situation without damaging your credibility?
It wasn't like, I was just a ride, to be honest, getting from point A to point B, and they were the only person that I had a ride with, so.
Well, there's Via.
No,
So let's be honest with me. Why are you with these people? You have a CPS case, which means that Protective Services is watching what you do, trying to make sure that you are an appropriate or would be an appropriate parent. And you are saying you're getting in a car with some guy who's a friend of a friend
Oh, no,
and this
that was a while ago.
ex-boyfriend.
That was, the friend of a friend was a while ago. I haven't talked to that person and. I
All
don't
right, so
know.
why are you in the car with this
Richard.
person?
Richard Earl Robbins, is an ex-boyfriend, so he was helping me out with little things here and there.
Is he the father of your child?
No,
All right. So again, you've been on CPS and I'm sure CPS gave you a service plan to do.
yes.
Have
and
you
I
done any of it?
Yes, I have been following it. I was in drug counseling classes that I was attending. I was doing UAs for CPS as well. I was just waiting for them to assign me my parenting classes.
All right,
That's what I was
so
waiting for.
drug counseling hasn't been going well for you.
No, it was. And then with the time being of being in here, I did take the substance abuse class. I did finish it. I had gotten into parenting classes in here as well. I brought it all with me. to show you that I have been doing everything that I've been doing. Also been in contact with my health counselor as well.
And
So,
how old are you?
I'm 25.
All right. So I'm assuming your child was placed with her grandmother as a part of a service plan?
Yes.
So do you have a legal case with them or no?
No, but they just recently served me my papers since I've been in here for 4 months. Her grandmother is wanting to fight for custody of her, so they served me my papers, which I also brought with me to show you, but
And who's your attorney?
I don't have an attorney.
All right, so is it a legal case or not? Because if it's a legal case, they'll give her an attorney.
I haven't looked at that case.
Okay,
This just happened recently, just happened this month, that I got served these papers
All
while
right.
being here incarcerated.
all right. This is what the court is going to do. There's $1,000 fine. That's going to be probated.
That's fine.
Just one moment, sorry. So there's going to be $1,000 fine probated. Taking consideration 2024 CR 5142. There's to be restitution of $114 to SAPD for drug testing. There's to be no contact with Richard Earl Robbins and Dennis Lee Brooks. 5 years deferred adjudication. 200 hours of community service restitution. There's to be CPS compliance. Proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. And the UA hotline. Probation. If CPS is testing her at least twice a month, then I'm fine with y'all relying on CPS testing. All right, so why did CPS take custody of your child?
She came out dirty when she was born,
For what?
methamphetamines.
All right, there's going to be a referral to felony drug court, and that's going to be in custody. And there's going to be a TAP evaluation in custody and follow all recommendations of TAP evaluation. She probably needs inpatient treatment somewhere. I can tell you what, on the civil side, they have a drug treatment program for people who have CPS cases. You maybe need to see if you can do that or not. It's completely up to you, but this is what I'm ordering. If for some reason they order you to do their program, their treatment program for mothers who have drug addiction, then they can do that. And we'll come back here and I'll consider changing my ruling. There's going to be field visits 1 time per month until further notice. And if felony drug court doesn't accept her, go ahead and do a referral to Esperanza Court as the second option. Probation, is there anything else? All right, and I'm assuming that CPS is going to give you parenting classes. If they do not, let's add parenting classes, but if CPS gives her parenting classes and she completes those, then it'll be acceptable here. All right. Is there anything else that you need from the court to be successful?
No, how long does that take
How long does what take?
evaluation?
Oh, it's about 2 weeks. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes,
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, Your Honor.
All right, we can go off the record. Here's the thing. You have an 11-month-old. I always tell people this all the time. You can't have a child and put them at Travis Park and say, good luck to you. Children are 100% dependent on their parents to take care of them. For example, your 11-month-old needs somebody to feed her, needs somebody to change her diapers. They need all of that. They need somebody to rock them to sleep. If you are not going to step up to plate and do that clean and sober, then you shouldn't be in that person's life. You understand?
Yes, Your Honor.
And the other thing, do not, and CPS tells you this all the time, and I would have CPS clients and I would tell them, work on your plan. Do not be getting out here and hooking up with another guy. And I say hooking up because that's what it is. Do not be bringing another partner in your child's life until you have yourself together. I love children, but here's the thing. Children are baggage. Consider a child a suitcase, and it's the suitcase when you take it to the airport that it comes back, that it's too heavy, and they're going to charge you extra for it. Maybe there are partners out here who will see you with the baby and say, you know what, but I love her and I want to be a second father to her child. But that normally doesn't happen. Usually it's somebody who's looking at your suitcase and thinking, man, this is a very attractive suitcase. Let me get in this household so I can open the suitcase and have fun with the suitcase. Or sometimes you have people who will look at your suitcase and say, I'm tired of carrying this suitcase around. Let me just throw it in the closet or throw it in the street, and whatever happens, happens. If you have no plans to do your service plan, if you want to continue to do drugs, just step out of your child's life and let somebody else adopt your child. You understand? From here on out, if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. All right, good luck to you. Francel Braggs. Good afternoon. Court is calling 2024 CR 1544, State of Texas versus Francel Vernay Braggs. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Michael
Defense?
Dwight going to the defendant, Your Honor.
Okay, could you repeat that?
Michael Dwight going to the defendant, Your Honor.
Okay.
I apologize.
No problem. And are you Mr. Braggs? Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Probation, this is an application. Mr. Braggs, did you review what's entitled application for deferred adjudication with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
And counsel, is this going to be an application for deferred as well?
Your Honor, I'd prefer to be regular probation, but that's up to you.
All right, thank you. All right, well, is he just applying for regular probation?
He's applying for deferred, Your Honor.
All right,
But I'm leaving it up to you. Either way, we understand.
all right, thank you. Mr. Bragg, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
And state, are you proceeding on the indictment as presented? All right. Mr. Braggs, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a 3rd-degree felony. Range of punishment is anywhere from 2 years to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Braggs, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you are to agree that you've been previously convicted of a felony for enhancement. Punishment is to be assessed at 6 years in the prison. The state is opposed to your application. They're taking in consideration night mag number 759930. Did you understand that to be the plea?
Yes,
Defense, is that the plea?
it is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not of that type, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No, okay.
And to the enhancement, how do you plead? True or not true? All right, state any evidence to support the defendant's plea?
The state officer states exhibit 1 in all attachments.
Any objection?
No objection, Your Honor.
All right. Deputy Laura, do you have any Kleenex for him?
We don't have Kleenex up here, Judge.
Oh. All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it?
Yes, ma'am.
All right. And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Probation, how long will it take for just the TAP evaluation? So what date are you suggesting to bring this back, just for me to get the TAP evaluation? All right. Well, you want to put it on the 13th? Or you want to put it on June 11th?
The 11th.
All right. So we're going to come back on June 11th. Counsel, if you want a full TAP evaluation, then that's going to put us in July. So, I mean, a full PSI.
That's fine. The tap is fine, Your Honor. I believe that's all it's going to take.
All right. So we're going to come back on June 11th. And there's going to be a TAP evaluation, and state if you can provide the court with the criminal history. All right. All right. So we'll be back on June 11th, and the court will make its